this morning's docket. Case number 114077 in the matter of Rebecca Randles.
May it please the court, Stan Haslett, appearing for the Disciplinary Administrator's Office. I would request 3 minutes in rebuttal.
3 minutes is granted.
Hearing occurred in this matter on May 12th of 2015. The respondent appeared in person with counsel Pedro Irigaray. Our office appeared through Alexander Walczak. I am appearing today as a result of Mr. Walczak's retirement. The respondent stipulated to certain violations of the rules, diligence, communication, termination of representation, 8.1, which deals with bar admission and disciplinary matters, and Supreme Court Rule 207, which had to do with allegations of lack of cooperation in the investigation. At the end of the hearing, Mr. Irigaray requested permission to offer supplemental exhibits from the respondent's file in the case. He did make a submission, but the panel did not consider those exhibits. It was stated in the final hearing report that they were not responsive materials and they were not timely filed. That submission is not in the record. I mean, if the respondent wants that in the record, it exists. I have no objection to it being in the record as we stand here today. The recommendation was at the hearing, Mr. Walczak recommended a 6-month suspension if the panel found that the respondent's misconduct was knowingly committed.
Can we talk about that recommendation for a minute, counsel? I'm just trying to get a handle as best I can on a fairly thin record, looks like to me, about what the agreement was between the Disciplinary Administrator's Office and the respondent on the nature of the evidence that would be submitted at the hearing and any resulting effect on Mr. Walczak's recommendation.
I think the agreement between our office and the respondent is set out pretty clearly right at the very beginning of the transcript.
That's why I want to ask you about it, because I don't maybe share your view that it's clear. You're talking about, I presume, where the chair asked the parties about the stipulation, and then Mr. Walczak responds, "That is my understanding, yes." Is that where you are in the transcript?
Yes, I'm on page 5 and 6.
Okay, I don't have the full transcript in front of me. I have an excerpt, so I don't have page numbers. That is my understanding, yes. And then Mr. Irigaray says, yes, it is. Tells how the stipulations came about, and says that the result, that the agreement between counsel that if Ms. Randles presents only mitigating circumstances regarding appropriate sanctions, then the disciplinary administrator will recommend public censure or non-published censure. And Mr. Walczak says, well, as though he's going to say something, and Marsh turns to him again apparently and says, fair and accurate as you recall.
Yes.
And at that point, Mr. Walczak says there's more to it than that. Does not provide for all the terms and conditions. And when the chair asks Mr. Walczak to define what those are, he responds, if in the event that the respondent presents matters which the disciplinary administrator feels inappropriate or not truthful, then I will seek a more significant sanction. So in other words, he's saying that he's going to evaluate, the way I understand that, he's going to evaluate during the hearing whether the evidence from respondent has been inappropriate, I'm not sure what that word means, or not truthful. In other words, if he personally doesn't find it credible, then he's free to seek something other than published or unpublished censure. Is that your understanding of that response?
That's correct, and that's consistent with the way we conduct those cases, because you really don't know what the respondent's going to say when you get to the aggravation and mitigation part of the case anyway.
I understand, but that puts the power in Mr. Walczak, does it not, to change his recommendation based on his evaluation of the truthfulness of the evidence?
Correct, that's what he's telling the panel.
Okay, and where in the record can I find, other than in his actual recommendation, where he says, I'm not going to make a choice, I'm going to put it on you, the panel, what his evaluation of truthfulness was? Are we just to assume it from the ultimate recommendation he makes? Did he, on this record, are you telling me that Mr. Walczak felt excused from the obligation to recommend either published censure or unpublished censure?
Well, I think if you look at his closing argument, he basically said to the panel, he left it up to them.
But he makes it turn in his closing argument on whether the panel evaluates her conduct as knowing or negligent.
Correct.
And that is different, in my view, from what I understood at the beginning that it would turn on, what the recommendation would turn on. I'm just having trouble matching them up. And I thought maybe if you knew of something else in the record I could look to understand.
No, I don't know of
better.
anything else in the record other than the way it starts out and the way it ends.
Okay.
I'm having the same difficulty, and I want to follow up with a question or two. Roughly characterized, there was an agreement between counsel that unless Mr. Walczak felt that evidence from the respondent was inappropriate or not truthful, then he was going to say either, I'm going to recommend to the panel published censure or not published. And that appears from opposing counsel, that was his understanding as well. And then in the closing, it was referenced, he doesn't appear to do any of that. And he doesn't even appear to say, for example, that I am sticking with the recommendation of censure that was in this agreement, or I'm not for these reasons, i.e., she was giving information that was inappropriate or not truthful. He just seems to be saying, panel, it's up to you. I'm not making any kind of a recommendation. So is there anything in the record to tell us why he did that?
Well, I don't think it's in the record. I think it's an acknowledgement on his part that they are the trier of fact. And there was much discussion.
But if he's the administrator, disciplinary administrator's representative, and the stipulation was agreed to because of his representation that he was going to recommend censure or non-published censure, and then he doesn't declare that he found reasons to depart from his recommendation, then why is the stipulation valid?
Well,
Can an argument be made that he's not lived up to the bargain or the agreement that was reached?
I don't think so at all.
Okay, help me with that then, please.
Well, I think there was evidence presented during this hearing through the testimony of the complainant and the respondent that could have led that panel to conclude that the respondent acted either knowingly or negligently. And I think what Mr. Walczak said at the end is that's the state of the evidence as I see it. You're the trier of fact. If you think she acted knowingly, then I think a suspension is appropriate. If you think that she acted negligently, then published censure is appropriate.
But that wasn't one of the conditions that he said would, if it were met, it would leave him to recommend a more significant sanction than censure. I'm having trouble following this. It just looked like the stipulation went out the window, and he said, panel, you've heard the evidence, you decide what sanction to impose.
You know, I think he told the panel that the stipulation might go out the window. And I think that the way the evidence came in, that panel could have concluded that she was acting knowingly or she was acting negligently. For instance, on the issue of whether she cooperated in the investigation, she said, I was overwhelmed by what was going on in my life. My father had died. I had all of these cases going on, and I really just wasn't paying attention to what was going on. But if you look at the transcript, she later on says, well, you know, I just didn't prioritize these things closely enough. She doesn't say I didn't receive any of these 6 letters to which she didn't respond, or 6 instances to which she didn't respond. She didn't say that my administrative staff didn't give it to me. She just said I didn't prioritize. So if you believe what she said,
I understand all that. Maybe my basic question is, if you've entered into stipulations, in other words, some sort of an agreement with opposing counsel in a case like this, do you have the ability to say, I'm not going to be bound by those stipulations. I'm throwing this open to the panel, and I am not going to stand by the recommendation that I told you earlier that I would make? Can you do that? And if so, under what circumstances?
Well, I don't think he, I mean, I think he did what he said he would do at the beginning. I think
Well, he said he was going to recommend censure unless their
Correct.
evidence came in that was not truthful or inappropriate. And there's nothing that I can find in the record where he said, aha, that did come in as untruthful and inappropriate, so I'm no longer bound by my recommendation for censure. So, panel, you can do whatever you want. And he then chose either to make a recommendation for suspension, which he did not. He instead chose to say, I'm not giving you any recommendation. I'm just trying to figure out, I guess, what the respondent got out of this deal in the stipulation, that she stipulated to violating all these rules. What did she get out of that from your office?
What she got from our office?
Yes. When Mr. Walczak says, panel, it's up to you on the discipline.
Well, first of all, he did say that published censure is an option here. I think, although maybe he didn't articulate it in a way that maybe we would have liked, the fact is that the evidence was there, and there was evidence from which that panel could have concluded that a more serious sanction was available. And again, I point to the record.
I understand all that. Maybe we're talking past each other, but what did the respondent get out of this stipulation?
Well, what the respondent
Didn't she basically plead guilty to violating all these rules?
She did.
And believed that was in exchange for a favorable recommendation from your office for censure, unless she did something to be untruthful, etc. And I can't find anything in the record that indicate that those conditions Mr. Walczak established were ever met. So it gets back to my basic question. You can either show me where in the record he says those conditions were met and I'm no longer bound, or the basic question is, can you just ignore the stipulation, ignore the recommendation, and say, panel, it's all on you?
Sorry, I don't agree that the stipulation was ignored. It would have been better had there been a statement about why I believe that I have the ability to recommend suspension at this particular time. However, if you look at the record, I think it exists in the record, both with respect to her explanation for why she didn't cooperate in the investigation, and both for her explanation about how she communicated with her client.
So in effect, what he did was say, there's evidence in the record to indicate that our stipulation agreement's no longer valid. And as a result, you can do whatever you want, panel, for discipline, because I'm no longer bound to give you the recommendation of censure.
I think the inference is that the evidence is in the record to allow me to say that suspension could be appropriate. Of course, it is nothing but a recommendation to the panel and to you.
He wasn't making a recommendation, it seemed to me. He was saying it's your choice. My recommendation is you decide.
Well, I would agree with that characterization.
Okay.
There's no evidence, is there, or finding by the panel that Ms. Randles was untruthful?
No.
So we are focused only on the language that if he found anything inappropriate, he could recommend a higher sanction. Is that accurate?
Right.
As the way he stated the
Well,
stipulation?
I'm a little confused of whether you think it was a recommendation now or whether you think it's just he threw it in their lap.
He says my recommendation is you decide.
Right.
You decide whether she should receive a suspension or she should receive a censure. And it depends upon whether you find it to be knowing or negligent.
Right.
So his earlier recommendation to the respondent was, I'm going to recommend that you be censured unless you do something in the hearing that makes me back off that.
Okay.
I'm not I'm not sure how else to ask this. Maybe some of my colleagues can help me out on this, but it just seemed that a deal was struck. And then your office said there is no longer a deal. But he never really said why there's no longer a deal. And you're telling us, well, that evidence is in the record. So I'm just curious whether this sort of thing can be done in the future when a respondent and counsel think there is an arrangement made with your office and then proceed through the hearing and find out at the closing argument that there is no deal. There's no recommendation for some reason that has not been articulated to them.
Well, I go back to the first pages 5 to 6, at least, of the transcript I'm looking at. I mean, when Mr. Irganagaray stated what he thought his understanding of whatever agreement there was, Mr. Walczak states what he believed it to be, and Chairperson Marsh says, so it sounds as though there's a stipulation to the underlying violations and the sanctions. There's a joint recommendation in the event that only mitigating circumstances are presented. Is that correct? I guess what I don't understand is if there was any sort of misunderstanding at that time, based on what Mr. Walczak said, saying I can make recommendations in the alternative, why there was no objection made at that time, and why in the closing argument, when Mr. Walczak made the recommendation that he did to the panel, why Mr. Irganagaray would not have been jumping up and down and saying this is contrary to what we agreed to. There is.
Are they objecting now?
I'm sorry.
Are they objecting now?
They are objecting now, yes, but not at the time the hearing occurred. I don't understand that. I don't understand why this record is the way it is, and there is no objection, because if you look at the closing arguments, Mr. Walczak makes his alternative recommendation. Mr. Irganagaray then has his opportunity to say what he wants to say. Wouldn't he have stood up and said, this is contrary to our stipulation, which is not, I mean, I wasn't privy to it, so I don't know exactly what was said. I've seen the email string, which is attached to one of the motions in the case, and I have seen what this record says. And, you know, in criminal cases, if you don't object to
well, aside from whether or not there was or was not an objection, or should have been or should not have been, just as you stand here today, what justified Mr. Walczak's, as you characterized it, alternative recommendation?
What justified it? Okay.
Yeah. And I'm not asking in sort of a de novo sense what justified it. What justified his departure from what I think everyone agrees, at least from reading the transcript, was an initial agreement to recommend no greater than public censure?
Well, there are two main areas of this case which I think are serious. The one is the lack of cooperation. And
right, but all that existed before. I'm asking you what happened in front of the hearing panel. What happened after all the parties showed up at the hearing that would have justified Mr. Walczak in departing from his agreement, and that agreement existed, you know, at that point in time, 9 a.m. or whatever time everybody showed up for the hearing.
Right. And again, the way we normally handle cases is to wait to make a recommendation until you see what the respondent says.
That would be the norm. That would be the norm, counsel, but not when you have a deal to the opposite effect. And here, according to all sides, that segment of the transcript represents that there was a deal. There was a deal. And something new had to happen for that deal to be scrubbed. And that's all we're all trying to reach. Where did that happen? How do we know it happened other than the implication from the non-recommendation or changed recommendation at the end?
Well,
And the way Chair Marsh, if I can just tag on to all of that, capsulized it was there's a joint recommendation in the event that only mitigating circumstances are presented. Is that correct? Correct, correct. So that seems to be the point where the agreement is the clearest. And so I think what I would add to the question is, what was presented other than evidence about mitigating circumstances that allowed the change in recommendation?
Okay. One of the things I've already spoken about, that's the lack of cooperation, which is characterized by the respondent in her testimony before the hearing, characterized in her motion to strike extra record material, characterized in her brief, in her exceptions, and she has the opportunity to talk about it today, which was a negligent fact. She was saying it was negligent. I was overwhelmed by what was going on in my practice, and her testimony at the hearing was, I just didn't give it priority. I had all this stuff going on in my practice. I didn't give it priority. Mr. Walczak gave the respondent 3 different opportunities to answer this complaint informally without it being docketed for investigation, and she ignored every one of them. And her explanation at the hearing was, I had other stuff going on. I didn't prioritize it. So that is something that came out at the hearing, which was not something in our possession at the time. The other thing I think is very important.
Her explanation wasn't credible, in other words.
Correct.
Okay.
Which the panel could find. Obviously, that's their job. The other significant thing that I think came out at that hearing has to do with communication with the client in this particular case. Our brief contains the various email correspondence that went from the complainant to the respondent, saying what's going on, and the responses come back time and time again saying it's just around the corner, it's going to be done, it's going to be taken care of. Well, at the hearing, and the respondent says that part of the lack of due process here is that the respondent didn't get a chance to say what she wanted to say at the hearing. But in fact, if you look at her 84 pages of testimony, she did explain many of the things, if not all the things, that she now has attached to her brief. But with respect to the issue of communication, she said, the question came from us and from the panel, well, how come there's nothing going back explaining why it is that you're not doing this? Because our explanation at the hearing was, well, we were waiting for some other cases to be resolved. We wanted some precedent setters before we actually filed this case. And her explanation for why there was no correspondence going back, or emails or letters, was that, I like to do things face to face, or I like to do them over the phone. So there is nothing that goes back. There is no letter. There is no email that goes back explaining why it is that we're holding off on filing either a paternity action or some sort of action against the church.
So what you have recited to us either was not mitigating circumstances as indicated by Chairwoman Marsh, or it was inappropriate or not truthful per Mr. Walczak. Is that right?
Correct.
All right.
And what you're explaining to us now, in my mind, is something that Mr. Walczak should have got up and said to the hearing panel, and then say, that is why I don't believe the stipulation or the conditions of the stipulation are now in place, and then give a recommendation that he gave. That is just not there. At least his change in what was being recommended is just not there.
I'm sorry, I respectfully disagree.
Okay.
I think he notified them right up front that this was a possibility. It's unfortunate that whatever the agreement was not in writing. I had a conversation with Mr. Aragonigaray before we came into the room. If you feel, it's become all about this stipulation, but the misconduct is there, and it's serious misconduct. And the respondent has had the opportunity at the hearing. The respondent in detail set out her narrative about what happened in her response to the motion to strike. She's had the opportunity. She set out her narrative on what happened in the extensive exceptions that she filed. She set out her narrative about what happened in her brief, and she's going to have the opportunity to talk here today. And in fact, she discussed at that hearing many of the things that she said she didn't get a chance to say. But Mr. Irganagray and I had a discussion outside today. I mean, if you conclude that this worked to her disadvantage, because again, it's just a recommendation. I mean, you can obviously give her what she was willing to accept, which was a censure. If you feel that this truly worked to her disadvantage, you can, and what Mr. Irganagray and I discussed, because I do want it to be fair, and I do want it to be right, and he discussed the possibility of remanding it so that she can say to a panel what she wants to say. If you feel like she has been disadvantaged standing here before the court because of our recommendation, then that is certainly there's the potential for that, to which obviously I would have no objection if that's what you told us to do.
I acknowledge that the first conclusion of law made by the panel says this, quote, based upon the respondent's stipulations and the above findings of fact, the hearing panel concludes as a matter of law she violated, and then it mentions all the rules. And it's a little bit difficult for us to review this and try to find out what the panel thought was significant, whether it was the stipulations or the findings of fact or both, to reach their conclusions, unless you'd be asking us just to review everything on our own and act as our own fact finders and say, yes, if we took out stipulations, for example, there'd still be enough to support these conclusions. But sounds like you have offered today for us to send it back to the panel so that can be cleared up. But some of the questions I think today were not just to try to take exception to the way this particular case was handled and that's it. We have a larger question in mind, and that is, as I mentioned, can your office make stipulations and then without really clarifying why they're backing out of stipulations do so anyway?
Well, the answer to that would clearly be no.
All right.
I respectfully disagree that happened in that fashion. But be that as it may, it is the most important thing that the respondent get a fair shake, and what should be done should be done. If you don't feel that she has, then a remand so that she can say whatever she wants to say. That's fine by us.
That would be, are we talking about a remand which would essentially allow the respondent to withdraw her stipulation to rules violations?
That's fine. If that's what you want to have
I
happen.
mean, again, it just analogizing to a criminal context, which we can't do entirely here, but if a prosecutor reneges on a plea deal, the remedy generally is to let the defendant withdraw from the plea.
That's fine. I'll be happy to put on the evidence.
I was just trying to clarify what you meant by remand. You didn't mean remand for a rehearing on a proper disposal only. You meant remand to ground zero.
I don't mean a remand to ground zero. I mean, she stipulated that she violated certain rules. To my way of thinking, the way I read all this is that she just didn't get to explain as well as she wanted.
Okay, so that points out the importance of my question then, trying to understand what the disciplinary administrator's position is in terms of proper remedy. I understood you a minute ago to say you don't object to a remand.
I don't.
But now I just understood you to say you do object to a remand if it's to a position prior to the time the respondent made stipulations.
Well, if you conclude it was unfair, I'd just say remand it. We'll start from ground zero.
Okay.
What is your recommendation for us today in terms of discipline?
Well, again, you can recommend what she was willing to accept. She's agreed to these rule violations with the advice of counsel. At this point in time, I will withdraw any recommendation of suspension. I would recommend to the court, based on her admission that she violated the rules, with the advice of counsel, that she received the censure which she was willing to accept.
Any further questions? Any further presentation?
No, sir.
Thank you, counsel.
May it please the court. I accept Mr. Hazlitt's offer that he's willing to put at the top end of his recommendations a public censure. The agreement that I reached with Mr. Walczak included that at the hearing, we would be able to put on mitigating evidence with which to recommend to the panel a non-public censure. And I would request that this court take into account the totality of what was presented and also the testimony that Ms. Randles will be providing, and then determine between the top end, as Mr. Hazlitt has suggested to the court, he's stipulated, which is the public censure, and a private censure based on the totality of the mitigating circumstances.
Is that all you want to talk about today, or do you want to talk about remand?
Based upon what Mr. Hazlitt has suggested, I don't think a remand is necessary. It is clear that Ms. Randles failed to respond timely. Unquestionably, she admitted that from the beginning. And to remand for that purpose, I think, is inappropriate. Clearly, there were issues with the client, and those issues are well set out in the briefing. I don't think it's necessary at this time to remand, and I respectfully accept Mr. Hazlitt's recommendation for the top sanction with our position that a non-public censure is appropriate. And if I may at this time,
Before you do that, why isn't the suspension appropriate under these circumstances?
suspension might have been appropriate.
It's not off the table for us, though, is it?
No,
But
obviously not.
so tell me why, under these circumstances, given the time period here, Mr. Iraganagaray, I think your client was originally approached in 2008 with representation, significant issues, at least she was raising in her concerns, which would lead to a lawsuit. And 6 years later, nothing has happened? And why isn't that? Why don't we look a little more closely at suspension, given those circumstances? And I understand there's a lot of intervening things that happened in those 6 years, but 6 years.
Your Honor, I think that is an excellent question, and that is precisely what we would have put on the record, calling witnesses to explain what happened during that period of time. And because of the agreement, the stipulation that we had, we did not present it. But it is not fair to suggest that nothing happened. A great deal did happen. It's just that the remedy that was desired by the client was not one that was readily available pursuant to the standard of the law at that time. As Ms. Randles will explain, the conditions legally were not favorable for the remedy that she sought. She made an allegation, for example, that she came to obtain a paternity lawsuit. Well, in fact, that was not the agreement that was reached between her and Ms. Randles on a signed contingency agreement. It was for something else completely different. And in order to be able to get the result she wanted, which was to be monetarily compensated by what she believed the Catholic Church had done to her, as well as to obtain ultimately a finding that the priest was in fact her father. There were certain legal requirements that in Kansas were not available. And Ms. Randles was working diligently, not only in Missouri, in a case that she filed attempting to do something similar, which initially appeared to be going in the right direction until all of a sudden the bottom fell out of that lawsuit. There were also other cases across the country trying to reach similar situations, and that created delay. I can tell you from personal experience, I participated with Ms. Randles in the cases in Kansas City, and these are tough, difficult cases, and the law just was not favoring what the client wished to do. Clearly, a lot of time went by, but it is unfair to characterize it as time with nothing occurring. I cannot defend that some actions clearly is why we stipulated. The agreement was we'd have to stipulate to everything. And as a result of that agreement, a ceiling was placed on what was going to be recommended.
But the stipulation, did the stipulation in any way stop you from presenting any evidence that you would have presented?
Well,
In mitigation of the possible discipline that the panel could impose, because it was not bound to accept the recommendation of the disciplinary administrator.
Absolutely, Your Honor. I was not limited by Mr. Walsack or the disciplinary administrator's office as far as the volume or the type of evidence that I could have presented in mitigation. It's just that with an agreement in place, rather than put on what would have been multi-day presentation, we limited it to just a few hours of mitigating testimony.
So it sounds to me like, but correct me if I'm wrong, that your brief and the arguments you've made thus far contain all of the sort of traditional arguments that would be made in these kind of cases. And then it also contains a due process claim.
Yes, sir.
And it sounds to me like you're essentially conceding, based on Mr. Hazlitt's recommendation to this court today, that the due process violations, to the extent they existed, have been cured. And you're essentially not arguing those anymore. Is that a fair summary?
By virtue of the offers that he's put before
Right.
the table, yes. But I fully recognize that you have the final authority as to what to do.
Right, so really we're back in the posture of, if everything I said is correct, we were essentially back in the posture of what I earlier characterized as an ordinary disciplinary case.
I believe that's true, sir.
Okay.
Why can't we take the findings of fact of the hearing panel and your exceptions, because you've said this wasn't right, here's the evidence to this. Why can't we just look at that and see whether the factual findings of the panel are supported by clear and convincing evidence?
The one reason that I believe that should not occur goes back to the fact that we limited our presentation and the amount of evidence presented and the number of witnesses that would have supported the evidence based on the stipulation. So that in that manner, by virtue of the agreement, not a full exploration of the issues was presented to the panel, and you are therefore working with a limited amount of information.
But that was a decision that you made, right?
It is a decision that I made in good faith, relying upon an agreement
Right.
that had been reached.
And now the agreement has been revived, it sounds like, based on Mr. Hazlitt's presentation. So I thought that's kind of where we got back to, is that if this is now and I'm going to, like my colleague did, put that in quotes, an ordinary disciplinary case, then we're really talking about sanction now, not about whether the fact findings are supported by clear and convincing evidence or whether the conclusions of law are supported by clear and convincing evidence. We're just talking about what's the appropriate discipline. Is that right?
I believe so, Your Honor.
Okay, I just want to make sure we weren't getting back off track. Thank you.
And I want to make clear, this court is not at all limited to the upper range of what Mr. Hazlitt's just put on the table.
I'm fully aware of that, Your Honor, and I
I mean,
think
for example, I get back to the findings of fact here. Paragraph 14 has a finding that says the respondent repeatedly promised that to the complaining witness, that she would be taking action soon. Now, are you telling me that that's not a true statement?
That is a true statement, but there are reasons for which the statements were made, and reasons for which the statements had to be revised.
I don't understand what you just said.
If
The
I may,
respondent
then,
repeatedly promised that she would be taking action soon, and that's to the respondent, to the complaining witness. And that's a true statement. So what else more do you want to tell us? That she had good reasons why she didn't deliver on those repeated promises? I mean, is that what we're talking about?
if I may, Your Honor, it is true that there were those occasions in which the complaining witness was told, "We will do something,"
Told by the respondent.
by the respondent. However, that cannot be taken in isolation. One must consider why those statements were not followed through. And the reason why action was not taken was not because the respondent was making a false statement to the complaining witness that she was going to do something and then purposefully not doing it. The reason why was because of the fluidity of the case law that was developing regarding the remedy that the complaining witness wished to achieve. This is not as if...
And
it
where
were-
is, and excuse me for interrupting, but so I understand where you're going, but the finding of the panel also is that not only did she make these promises, but she didn't ever inform her client of all these excuses that you are offering as to why she didn't fulfill the promise. And so if we know those two things, and we know that you have these excuses, why can't we process that the way we normally do in a disciplinary case?
And you certainly have the authority to do so, Your Honor. I'm not suggesting that you do not. All I'm asking the court to consider is that the final report from the hearing panel is based on a limited amount of information which was presented to the panel based on the good faith belief that an agreement had been reached. At the time that and I would call it a breach of the agreement, occurred, it was too late. We didn't have the opportunity at that time to bring in witnesses, to develop the case in a manner that perhaps would have explained to the panel the totality of the circumstances surrounding the statements to the complaining witness and the full reasons why those statements were not able to be complied with.
Give me an example of some of the circumstances that the panel did not hear that you would have put on in mitigation of what I just explained about these promises being, because communication with the client is one of the allegations, and it looks like that was violated. And I think you stipulated it.
And Your Honor, I'm sorry, I interrupted you.
It seems like you stipulate to it. So what evidence did you not present in mitigation of that? What's not in the record?
Your Honor, first, I want to be absolutely clear that we are, and I am not suggesting to you that communication between the respondent and the complaining witness was what it should have been. I'm not suggesting that at all. If I did not believe that there had been some errors, I would not have stipulated. I simply would not have. So if I'm giving the court the impression that we have an absolute defense to failure to communicate, that is an erroneous impression.
Or any of the allegations. I mean, really, don't you stipulate that you did all the things that are alleged? You just say, we had reasons that should mitigate what the discipline is.
And we presented, Your Honor, what we thought were mitigating circumstances.
So identify for me some mitigating circumstances that you didn't present evidence on.
And if I may respond in this manner, Ms. Randles has that available and she will present that to you in her statement. Off the top of my head right now, I can tell you that we would have presented additional witnesses to talk about the communications that existed between Ms. Randles and the client. Ms. Randles can testify about a number of phone calls that occurred between she and the client. Those factors were not fully explored at the disciplinary hearing. But for me at this moment in time to go back and tell you with great specificity A, B, C, and D, I'm not prepared to do that. Ms. Randles is.
Why were you precluded from putting on that evidence at the hearing?
I was not. I was not precluded, and I do not want to suggest to this court that I was precluded. My limitation was self-imposed based upon the agreement that I had reached with counsel. I do not want to suggest that I was in any way limited in presenting or exculpatory evidence. I was not.
Well, according to Chairwoman Marsh, there was a joint recommendation in the event that only mitigating circumstances are presented, which indicates you were free to put all that on. That was part of the agreement.
That is true, Your Honor.
So I'm a little unclear as to how, if you were allowed to do that by the agreement, why you chose not to. You seem to suggest that you wanted to honor the agreement, therefore you did not put on mitigating evidence.
If that's the impression that my response provided to the court, then that impression is incorrect. We were allowed to present mitigating circumstances. We did not present the full complement of mitigating circumstances and the witnesses with which to support that position. And again, I did that based upon an agreement that I believed existed.
Is it fair to say that then that decision, what you described as a self-imposed limitation, it was really a strategic decision on your part that what you did present was sufficient in light of what you expected to happen, which was that Mr. Walczak would only recommend published censure. But frankly, the strategy might change if you had known in advance that there might be a higher recommendation. The weight of mitigating evidence in your sort of strategic approach to the hearing might have changed. That's what it sounds like you're saying.
Your Honor, I think that is a fair interpretation of what I'm saying.
But it seems difficult to accept the strategy argument when all you're getting from the disciplinary administrator's office is the recommendation. So their recommendations are disregarded by the panels all the time. And the panel's recommendation to us are disregarded, I think about a third of the time or so. They keep track even of when we deviate from the panel's recommendation. So given the circumstance that you've got at least two other bodies that aren't bound by anything other than their judgment, it seems like there's not much of a punch to pull. I mean, see, if you've got this evidence, you're really just talking about cumulative evidence rather than the notions there, and you put them and put forward. So I'm still trying to figure out how you're disadvantaged in a context where all you're getting is a recommendation from the disciplinary administrator.
Well, Your Honor, historically, a recommendation from the disciplinary administrator, although not binding on the panel, and clearly not binding on this court, does carry a certain degree of weight. And we had certainly understood from the beginning that the panel could have chosen a different sanction than that which was recommended. And we certainly understood that there had been violations that in good faith we could not defend. So the degree of exculpatory evidence, that decision was mine alone. It was a tactical decision to put on this much and address the panel based upon the recommendation. And the amount of time that was allocated for the hearing, again, was not a limitation imposed on me, but an agreement reached with Mr. Walczak that based upon the stipulation, all we need is this amount of time. So I don't know how else I could respond to your question. It was my decision to limit the degree of exculpatory evidence to that which I presented. It was clearly known to me and to Ms. Randles that the hearing panel could reject and had the authority to reject the recommendation made by Mr. Walczak. And we clearly understood that this court did not have to accept the recommendation from the panel if it supported the agreement that we had reached.
You characterized Mr. Walczak's actions as a breach. Did you object at the time that he made the recommendation? You've frequently appeared in front of me at trial court, and if someone, a prosecutor, someone would have breached an agreement, you'd have been screaming up and down, at least based upon prior experience. Did you object, or did you place anything in the record? Counsel, this isn't what we agreed to. I'm withdrawing everything that happened. Anything like that?
I did not, and that's my fault. I just hope that that fault on my part does not end up causing Ms. Randles harm. I relied on an agreement. The record is absolutely clear on the fact that when Mr. Walczak said what he did, I did not object. And there's something else I want to put on the record. Mr. Walczak is a very honorable man. And when I use the term breach, I don't want to imply that I believe that he was somehow intentionally or maliciously trying to do harm to Ms. Randles or to me. I have referred to it in conversations with Mr. Haslett as perhaps a misunderstanding at the end. Be that as it may, I believe harm did occur. I believe that it was a violation of the agreement that we had reached, and I'm not impugning to it bad faith on Mr. Walczak's part when I used the term breach.
Counsel, let me clean up here. What is your proposal for how we proceed? I've heard all kinds of options being offered this morning, and I just want to make sure I understand exactly what your proposal is.
Thank you for the opportunity, Chief Justice. I know that you have unlimited authority as to what to do in this case, as you do in every disciplinary hearing. I would like for the opportunity to have you hear Ms. Randles. I see my time is up. She's prepared a statement that I believe is important for this court to listen to. I would respectfully request that the agreement that Mr. Walczak and I had reached, and which was reinforced by Mr. Haslett's statement to you, be favorably considered by the court, fully recognizing that you are not bound by it. And I would further recommend that upon the conclusion of all of the arguments and Ms. Randles' testimony, that based upon the totality of the circumstances, that a non-public censure, a private censure, be issued by this court.
And can we do all this without sending anything back to the panel? In other words, we would look at the record and we would look at what the findings and conclusions are from the panel and all your exceptions and Mr. Haslett's offer today in your request, and somehow put all this together without any kind of further action outside of the Supreme Court.
I believe you have that authority, Your Honor. As was discussed earlier, I believe, with Justice Biles, you do have the ultimate authority to make a determination as to what, in your best judgment, is the appropriate result.
Well, one thing I want to avoid as an example is that we would look at the exceptions you and your client have taken to the report and said, this was too much of a procedural problem here. We've got a purported agreement, stipulation, agreed to recommendation for censure, private or public, and it would just take an awful lot of work for not a huge payoff at the end to try to sort through all that. It's just too procedurally difficult, if not impossible. So if the court, for example, just said, we thank you for your exceptions, but we are declining to accept your exceptions, and we're going to basically adopt the hearing panel report, and then we'll decide what discipline is imposed, that you see a problem with that. We're trying to be fair here, but this, to be honest, I've never seen a situation like this in my time on the court, and we're trying to work through it.
I understand that this is a very unusual situation. I believe that the court has the authority, based upon the totality of the evidence before the court, based upon the statements from Mr. Haslett, and based upon the recommendation from counsel, to proceed to reach a determination. You do not have to accept the panel's recommendations. And perhaps it was Justice Biles or Justice Rosen, forgive me, I don't recall which of the two of you, made the observation that at least 1/3 of the time, the recommendations from the panel are not followed. So ultimately the decision is yours. And our request would be that the agreement be enforced, with the top sanction being public censure, and my request that, based upon the totality of the circumstances, a private censure be issued.
Very well. Thank you, counsel.
Thank you, Chief Justice. With that, I would like to call Ms. Randles for her statement, with your permission, because I'm out of time.
Very well. Thank you.
Thank you, sir.
May it please the court. Thank you for allowing me a few minutes to speak, to offer my own apology and a brief defense. I apologize to this court, to Mr. Haslett, and to my client for engaging in behavior that has brought us here today. You see before you a lawyer who is both remorseful and, quite frankly, bewildered by the predicament in which I find myself, because I was a participant in the call in which the agreement that we've spoken about was made. As part of that agreement, I could offer no defense, only mitigating circumstances, and I abided by that stipulation to the letter. Defenses did exist to SI's complaint, but there is no defense to my failure to respond timely and appropriately to the disciplinary counsel, and my failure to communicate with my former client subsequent to the filing of her complaint. Those failures on my part have no meritorious defenses, only mitigation, due to the circumstances existing at that time. I stipulated for two reasons. First, I recognize that I did fail to respond timely and appropriately to the disciplinary administrator, and I did not adequately communicate with my client after she filed her complaint. For those actions, I am truly sorry. I would never, ever knowingly harm a client, nor would I knowingly act in any way disrespectfully to this court or the disciplinary administrator. The law is my life. I derive my greatest sense of accomplishment and meaning attempting to right injustices through the court system. I take the most difficult and challenging cases, cutting-edge cases without clear legal precedent, on matters involving sexual abuse and abuses of power by the church, the government, professionals, and other institutions. I cannot fathom being unable to continue that path and wish to minimize any risk of that occurring. The second reason I stipulated is that I am a single mother raising a special needs child alone, and I'm the foster mother of a 2-year-old great-nephew. I cannot survive a suspension and provide for my children. I have no fallback. The practice of law is my only means of support. If I had any inkling that the stipulation would be discarded by the prosecutor, I would have offered an entirely different defense, not to my failure to timely respond to the complaint or to my actions after the complaint was filed, but to the perception that I had a client for 5 years and did nothing for her. That impression is entirely false. SI came to my office in September of 2008, outlining 13 legal issues she needed addressed. One of these was to learn the true identity of her father, whom she believed to be a priest in the Diocese of Wichita. Following that meeting, she signed a contingent fee agreement for me that alleged priest abuse as the reason she came, but then sent a letter outlining 11 different issues for me to review. Days after meeting with SI, she received an eviction notice from her landlord regarding her Section 8 housing. I helped her get a review of her property and established that her home was not habitable. She also told us about being stalked by a man who had raped her. We tried to get her help housing in a different area, including Florida and Kansas City, to get away from that situation. She opted to stay in Wichita. Other issues we handled in 2009 included reviewing her psychiatric malpractice claims and finding that there was no cause of action for her there against ComCare. We began investigating her claims regarding being fathered by Father S. To that end, I spoke with her prior counsel, learning that Bishop Jackal would not allow genetic testing without the signing of a waiver and confidentiality agreement. I reviewed all the case law in Kansas under the Uniform Parentage Act and did a national search as well. I found 2 cases going through the trial courts, Laddie in Massachusetts and Nathan Bond in St. Louis. These were both recently filed and had no findings from any court. Bond was particularly heartrending, as that boy had a congenital brain disease or cancer and sought genetic information to battle that disease, as well as financial help from the Franciscan order where his father was a priest. We watched those cases closely. Even with those horrific facts in Bond, both cases were unsuccessful. I also researched HIPAA, GINA, and the Kansas Adoption Acts. None of those provided SI with a right to require her father to provide her with his personal medical information. SI also made a claim against her putative father's estate. We requested and reviewed all of those records to determine whether the will contest would impact her claim that Father S. was her real father. Additionally, we helped her with her orders of protection against the father of her child and gave her counsel regarding her child's alleged sexual abuse. In 2010, I met with the media on her issue, and Sasha Sanders started investigating to find out who had information to support SI's claims. We were never able to find any corroborating witnesses except SI's mother. I also began background investigations on Bishop Jackal. I received copies of the official church responses in the Bond case. The Franciscans wrote a letter to Nathan Bond saying they had no moral or legal responsibility to make any kind of payment to him. Bond died that year without receiving any help from his father or from the church that required his abandonment. From the writings SI sent us, it appears that SI borrowed money from a friend and promised to repay it from the lawsuit from the church. We began getting emails asking for a date certain for filing. In November 2010, we called SI for a meeting to discuss all of the issues in her case against the church. In that conference, I explained in great detail the difficulties of her case and emphasized that if she went forward with it, as opposed to accepting a confidentiality agreement and waiver of some kind, she would be in the dangerous and risky position of being a trailblazer. She seemed to understand that, and her subsequent emails often refer to that conversation. However, we also began receiving emails from her saying that she had a constitutional right to her genetic information. We explained that she did not, but she had received legal counsel from a friend that was not a lawyer, and we had to remind her repeatedly that the law was not as she understood it. We continued working on her case and intended to file it in 2011. I began a demand letter in April 2011 after having received information from Carmen Durso about the Laddie case he filed. Also, a New Mexico case, Tedford, came down that opened the possibility that a lawsuit might be successful. Then, in June, I told SI that I hoped to file her case in the next couple of weeks to set an appointment, and we would pin that date down. But on June 24th, 2011, Roy versus Edmonds came down that destroyed the paternity action in Kansas that we had intended to file. Nonetheless, I did not give up on SI. She had an issue arise in which JJ enrolled her son in a diocesan school against her wishes and against the parenting order. I helped her craft a response to the diocese and resolve that issue. We could not go forward with that matter while that matter was on the table. So after resolution, I went back to work on her case. I had filed a Missouri case, John Doe 60, with legal issues that were similar to hers. I told her I wanted to run that case ahead of hers and use it as a learning tool. I did that because I knew that I had filed many other cases against the Kansas City St. Joseph Diocese, and at some point they would likely enter a settlement agreement and he would recover, even if he was not entirely successful on all of his claims, if I could just keep his case alive. Initially, I was very successful on John Doe 60's case, winning the motion to dismiss in the fall of 2011. Then, we lost the motion for reconsideration. That case was kept alive, but it did not resolve until 2014. On other matters, I counseled SI regarding continuing her orders of protection against JJ. We discussed her custody concerns, and I explained to her that I don't handle family law issues. And we reviewed psychological records and evaluations of her son, KJ. SJ also brought to us her latest concerns regarding her psychiatric care at Via Christi. In 2012, I continued working on investigation on SI's matter. I met with another woman who had very similar issues to SI that involved a bishop who had raised 2 children secretly. I also reviewed a Wichita Diocese sex abuse case. Those cases ended up going nowhere because the statute of limitations had run on the Wichita case, and the mother decided to do nothing regarding the bishop because she understood the legal difficulties that we faced. I also spoke to Richard Serban in Pennsylvania, who represented a woman impregnated by a priest. Despite all of the publicity and the legal need, the law was not moving in the direction I had hoped. The Missouri case, John Doe 60, stalled, awaiting a decision on whether the diocese owed any duty to the family for a priest impregnating his wife when she sought counsel from him regarding her employment with the diocese. While we were being thwarted on SI's case against the diocese, we worked with her on other issues. We tried to assist her son, who was being bullied at school. We provided her with information on Social Security disability, and we helped her get her student loans canceled due to disability. But there was also some good news that came about. In April of 2013, Bishop Jackal was moved to Dubuque, Iowa. We hoped that a new bishop, who didn't have the same predilection as Bishop Jackal, would be more sympathetic to SI. With the new pope, we believed a new chance was emerging for action for SI. Unfortunately, no new bishop was named until 2014. The last personal contact I had with SI was approximately September 2013, when I told her of my father's illness that subsequently claimed his life. During my father's final illness, I gave Sasha Sanders the responsibility for continuing communication with SI. Sasha did that. I did not directly communicate with SI during the months of October, November, and December. In January, she filed this complaint. At no time did I ever charge her for any of the services I rendered to her. After she filed the complaint, I totally fumbled. We were involved in a multi-week arbitration trial involving 44 plaintiffs the day the complaint came in, and continuing on for many weeks after that. This complaint went unanswered. It went unanswered until August. That was unacceptable, improper, and a bad reflection on me as an attorney. I profoundly apologize for those actions. Looking back now, I can't imagine what I was thinking, but I can tell you, to this day, my memories of that time frame are a blur. We used to greet ourselves in the office with "Happy Groundhog Day again," because every day was the same. More depositions, more deadlines, more motions for extension of time for deadlines that we couldn't make, more whack-a-mole hearings, which were motions to dismiss, where I would appear and argue against anywhere from 4 to 7 attorneys from the diocese. The diocese spent over $7 million defending the cases I had brought. At my legal rate of $350 an hour, that's 20,000 hours of legal work hurled at us. I was working 15-hour days, 7 days a week, and still I wasn't getting it all done. The strain became so great on us that we contacted 2 law firms to help us, Pedro Irigaray and a law firm from Minnesota. The Minnesota firm declined because of the volume of work. Pedro graciously stepped in, and he and I tried 3 multi-week cases together between 2013 and 2014. Additionally, I tried 2 other multi-week cases and briefed and argued 4 appeals, resolved 3 cases against the diocese and Father Radigan the week before they went to trial, and we lost 1 on summary judgment just before the trial. And it fell to me to help her learn how to function. At this time, my son and I were also living in fear. I began receiving death threats. I had the tires on my car mysteriously go flat, sitting in my driveway. 11 times. I had to buy new tires because razor blades managed to find their way into the treads. The door on my car was keyed and the gas line disconnected or cut. I caught a member of the Catholic League driving on my street with the words, "Woe to those against Bishop Finn," emblazoned on a sign in the rear vehicle window. To top it off, my house was placed on the dangerous properties list in Kansas City because the concrete in the basement, the garage, fell into my basement. And I had to litigate against the insurance company for 4 years, trying to get my house back into a livable condition. In this perfect storm of daunting professional demands and challenging personal crises, I dropped some very important things. Most importantly, professionally, I did not timely respond to the complaint filed by SI, and I failed to communicate with her after it was filed. On a personal level, I missed my son's induction into National Honor Society. That may not sound like a big thing, but I'm so proud of him because he is the first student in North Kansas City high school history to go from an IEP to National Honor Society. And I miss supporting him in that amazing accomplishment. Please know, I would never have missed his induction ceremony under any other circumstances. Likewise, I can envision no other set of circumstances that could possibly coalesce that would cause me to neglect my professional responsibilities to this august body as I did in 2014. Once again, I apologize with deep remorse for my failings, and I apologize to my former client. Thank you again for your time and your patience. I ask for your leniency as you review the entire record, or that you send the matter back to a new hearing panel to allow for complete defense to the complaint. Thank you.
Thank you, counsel. Do we have any questions for either counsel? I see none. Thank you.
Thank you.
You reserve 3 minutes for rebuttal.
Your Honor, I think I don't intend to argue about anything that was said here by counsel and respondent. I do think I, under the circumstances, need to make myself available to answer any questions that you do have of me. I would just say, you know, it's my job to make sure that the confusion and problems that came up in this case don't happen again, and I will certainly do that. I do appreciate the comments that Mr. Irigoyen made about Mr. Walczak, because in my heart of hearts, this was not an intentional thing. This was unintended consequences, and Mr. Walczak, and I think Mr. Irigoyen agree that Mr. Walczak's about the most honorable guy that I know. There may have been a mistake made here, but I don't want it to reflect on his legal career in any way, because I don't think it should. But I'll answer any questions that you have for me.
I had 2 questions. The first, did I understand you in your opening presentation to say that you had no objections to any of the respondents' appendices to their brief? In other words, whatever has been sent to this building on this case, you are not objecting, or did I misunderstand you?
No, you did not misunderstand me.
All right.
I do not object to anything that's attached to the brief or the exceptions or the objection to the motion to strike. No objections.
My second question is, I'd like to hear from you on what you propose on how this entire matter be resolved. I don't mean a particular disciplinary recommendation, but just the situation that we find ourselves dealing with. One option, for example, had been mentioned, was a full remand and just start this whole thing over, versus on the other end of the spectrum, I suppose, looking at what we have before us and trying to come up with an opinion that deals with findings of fact and conclusions of law, and then the discipline,
Well,
or something in between.
I do kind of feel like, as was said by Justice Stiegel, that we're back to the kind of the original disciplinary case at the present time. There is a lot of material attached to the exceptions and to the brief, which is in essence evidence of mitigation. Not exculpatory evidence, but evidence of mitigation. So I'm comfortable with the court, with the panel hearing report, with the briefs filed by both parties, with the additional exhibits that you have. Again, as I stated earlier, the respondent has had, including today, a number of different times to tell her story, and it is told in detail, 4 or 5 different times, with attachments, appendices. So I mean, I'm comfortable submitting it to you. I think all the evidence is there that you need to make a decision.
Very well, thank you. Any further questions? Any further presentation?
No, sir.
All right, thank you, counsel. We thank you all for your arguments this morning and this afternoon, and the court will take this matter under advisement.